When two people marry across borders, their marriage is often governed by multiple legal systems. This is especially common when one spouse is Muslim and the other is not, or when the marriage takes place in a country with dual legal frameworks. Hello, I'm Mahmoud Kilani. I advise law firms, companies, and investors across Europe on legal, regulatory, and Sharia compliance risk in the Middle East and North Africa region. In Islamic law, marriage is not just a social contract, it is a legal and spiritual bond. A crucial part of this contract is the Mahr or dowry, which is agreed upon before marriage. The Mahr can be immediate or deferred and serves as a financial right of the wife. Civil law, however, treats marriage primarily as a contractual and property arrangement. Divorce settlements typically consider property division, alimony, and child support, often without consideration for religious concepts like Mahr or dowry. This difference can create complex scenarios, particularly in international marriages, where one partner seeks divorce in one jurisdiction and the other in a different system. So what are the financial implications under Islamic law? Under Islamic law, financial obligations upon divorce include Mahr, dowry, a fixed amount agreed at the time of marriage. If deferred, it becomes immediately payable upon divorce. Mut'a, or compensation. Some schools allow additional compensation for the wife's welfare, especially in cases of talaq, divorce, initiated by the husband. Maintenance or nafaqa, obligations to cover the wife's living expenses during the waiting period, al-idda. Importantly, these obligations are calculated individually for each case. The husband's wealth or the wife's previous income may not significantly affect the amount owed. This can sometimes make the financial outcome more predictable than civil divorce, which often involves complex property and income evaluations. A real-world example. A woman married in Saudi Arabia to a foreign husband may receive her full deferred mahr even if the marriage ends after only a year, regardless of her personal financial status. Now here's where it gets interesting. Civil law financial reality. Civil law approaches divorce with a focus of equitable distribution and spousal support. Key aspects include property division. Assets acquired during the marriage are divided according to statutory rules, which vary widely between countries. Alimony. Long-term financial support may be awarded to ensure the lower earning spouse maintains a reasonable standard of living, and child support calculated based on the child's needs and parents' income. Civil law also recognizes prenuptial agreements, but international enforcement can be difficult. For example, if a prenuptial agreement signed in the United States conflicts with Islamic obligations in the United Arab Emirates, for example, courts may reject parts of it. International marriages often face double exposure. Civil courts may enforce property division and support, while Islamic courts may still claim rights like mahr. This can lead to legal and financial disputes that drag on for years. But here is the real issue. Case study of conflict. Consider a couple married in Egypt, a Muslim majority country but living in France. If the husband initiates a civil divorce in France, French courts may focus on shared property and alimony. Egyptian courts, if approached by the wife, may insist on the full deferred mahr and additional compensation. This dual liability creates financial pressure and requires careful planning. Many international couples don't anticipate these overlapping obligations, leading to unexpected outcomes that can far exceed what either spouse expected at the time of marriage. Here's what most people don't realize: mitigation and legal planning. For international couples, clarity at the outset is essential. First, marriage contracts explicitly state financial obligations in both religious and civil contexts. Second, legal advice. Consult both local civil lawyers and Islamic scholars to understand potential scenarios. Third, prenuptial agreements, if possible, create agreements that are enforceable across jurisdictions. Additionally, some couples use arbitration clauses to specify which system will govern disputes, which can prevent prolonged litigation. So, to wrap this up, Islamic divorce focuses on contractual and religious financial obligations like mahr and maintenance, nafaqah. Civil divorce prioritizes equitable distribution and support based on lifestyle and earnings. International marriages can expose couples to dual financial responsibilities, sometimes doubling the potential cost of divorce. Careful planning and legal guidance can reduce uncertainty and protect both parties. Ultimately, understanding both systems isn't just a legal necessity, it can safeguard personal and financial well-being, ensuring that the end of a marriage doesn't turn into a financial nightmare. Now, I think I covered all the points of this topic. Thanks for joining me today. If you enjoyed this discussion on Islamic divorce versus civil law, don't forget to like, subscribe, and hit the notification bell. Thanks for watching, and see you next time.